this presentation. Initially, it was due for Judge Oosthuizen to attend to the presentation, but he was then allocated 3 days, and he said he might not be able to fill 3 days with what he has. So, therefore, I am seeing you sooner than later. I thought once I've seen you on Sunday at the opening, that would be it. But it is always a pleasure to see you again. You will see I've come with files, but hopefully I won't delve into it, but it's just for just to have the necessary resources with me. You will see my court rules is falling apart. It is well used, and I hope you have followed my advice by marking yours properly in anticipation of the exams that's coming. Right, so I'm here today to just discuss the issue of the residual court role, but more specifically the undefended matrimonial matters. You will appreciate that this is something that we deal with quite extensively, but it's something that you would not have had any exposure to in the lower courts. Nowadays, unfortunately, it's quite easy to get divorced. And I would like to kick off my presentation by referring to the words of the learned Justice, the Judge President Damasep, when he said in the matter of Fuchs versus Fuchs, the following: the divorce law of Namibia is archaic and demonstrably in need of reform. The government of the day has inexplicably failed to initiate the much-needed reform. Under our current divorce law, when it comes to considering dissolution of marriage, it matters not that the spouses do not love each other or that the marriage has irretrievably broken down. The court may only grant divorce upon proof that a spouse committed a matrimonial offense. So, unlike in South Africa, where their legislation has changed and that a divorce would be dealt with on the basis of the marriage irretrievably broken down, that doesn't apply to Namibia. The grounds of divorce is regulated by, as the Honorable Judge President said, archaic legislation. And by just looking at the dates of the ordinances that is involved here, you will absolutely agree with me, this is archaic. It dates back to 1935. The divorce matters are regulated in Namibia, number one, by common law. Secondly, the Divorce Amendment Ordinance, 18 of 1935. That is the date of birth of your grandmothers and grandfathers. And then they're still fairly young. And this specific amendment was amended the common law by setting forth additional grounds of divorce. The Matrimonial Cause Jurisdiction Act, 22 of 1939, and then the Matrimonial Ordinance number 25 of 1955. Unfortunately, just before the necessary amendments were effected in terms of the Divorce Act, which is Act 17 of 1979, which is applicable in South Africa, this does not affect Namibia. So we are still stuck in the dark ages for all practical purposes in this regard. What is also relevant, but this is more with relation to marriages, is the Native Administrative Proclamation Act of 15 of 1928. So it's even older. This proclamation is a default marital regime system for marriages outside the former police zone. The proclamation provides that such marriages are by default out of community of property and unless the parties specifically agree to the contrary. Now, any of the colleagues that have worked in the north would know that the system is in place still in the north, And a lot of criticism has been leveled against this piece of legislation, but it is yet to be revised or repealed. So it is still applicable. The reason why I make specifically why this is of relevance is when it comes to the actual divorce and the marital regime that is considered. Now, there are 4 grounds for divorce in Namibia. First one is adultery, then malicious desertion, which may include constructive desertion, incurable insanity, and declaration of a habitual criminal. Now, adultery and malicious desertion, and in effect also then constructive desertion, derives from the common law. Incurable insanity and declaration of a habitual criminal are statutory grounds. And you will remember I referred you just now to the Divorce Law Amendment Ordinance 18 of 1935 that amended the common law. And it amended the common law by adding these 2 grounds of divorce. When it comes to a divorce action, all 4 of these grounds can be found in the action for the dissolution for the marriage, but that would be extraordinary. That would not be the norm. Because that is really calling literally all pockets to try and to get a dissolution of marriage. I'm not going to deal with the grounds of divorce in too much detail. I do not know whether any of the other lecturers have or will deal with it, but I will just briefly touch on what is malicious desertion, what is constructive desertion. Now, because we are still operating under very, very old legislation, we are lucky enough to have a little booklet, well worn and well used, which is the Divorce Handbook. It is very valuable when you deal with matrimonial issues, and it refers to extremely old cases, but sometimes you can find a lot of guidance in old case law. Now, the definition of malicious desertion appears to be that it takes place when a spouse without just cause either physically leaves or remains away from the matrimonial home, intending not to return to it, or otherwise comports him or herself as to convince the other party that he or she has an intention of bringing the relationship to an end. So we have a lot of matters where one of the spouses just move out. Summarily move out, kind of go on with his or her life, have no intention of returning. That would then be malicious desertion. There would then be a clear indication that he or she have an intention of bringing an end to the relationship. But it's not just moving out of the common home. There's also other examples, which is quite interesting, set out in this Divorce Handbook, like refusing marital rights, insistence on intercourse only with contraceptives, which is in general unreasonable or regarded to be unreasonable, and therefore it equals to malicious desertion. However, supervening incapacity to perform sexual intercourse is a just cause, and therefore it would not amount to malicious desertion. The last one, supervening incapacity to perform sexual intercourse, would be, for instance, where the husband has been in a accident, he is unable to have intercourse, unable to have an erection, so therefore unable to conclude or proceed with marital rights, and because of that physical condition, it can then not be regarded as malicious desertion. You will find that in your particulars of claim in these matters, in a lot of times, especially obviously the men, but also women, would list one of the grounds for divorce is refusing marital rights. It unfortunately happens that when the parties drift apart, this is probably one of the matters that is left, and that is not attended to. So, refusing of marital rights is often listed as a ground for divorce. Then, constructive desertion is a species of malicious desertion. It takes place when the defendant, with an intent to put an end to the marriage, does not leave the matrimonial home, but he is guilty of conduct which either compels the other spouse to leave or to render it clear that the marriage relationship can no longer continue. Now, malicious and constructive desertion are the two main grounds for divorce. Adultery is also up there, following short on its heels, but this is the majority of the cases that you will find is the grounds listed is malicious and constructive desertion. When it comes to malicious and constructive desertion, there must be an order of restoration of conjugal rights that is granted before a final order can follow. Now, we'll deal with RCR orders shortly. But what I'm saying to you is that in principle, there cannot be a final order of divorce. There is, however, a case law emanating from the Northern Division, where the Honourable Judge have ruled that where there is domestic violence and the one party is in danger, serious danger, that it would not serve a purpose to restore conjugal rights, because it would place the other party in danger, and he or she might also be prohibited by means of a court order in the form of a protection order, the interim interdict. However, as it stands, that is contrary to the rules. We have not, there is no, as far as I know, any cases from the Supreme Court in this regard. Some of the judges elect not to follow that route and would grant a RCR order, even if it is in a truncated manner, instead of the long period that is granted for RCR, rather make it in a truncated manner, and but that must be by agreement between the parties. It would not be in a undefended matrimonial matter like this. Examples of constructive desertion, and I think that some of these are just things that are listed out of habit by legal practitioners, that does not always ring as true, but trying to convince the court that these are the issues. It's like a little rhyme that they have: failing to show love and affection, inviting constant arguments. Then there's also issues like squandering of the party's income and on alcohol and gambling. So this is unlawful conduct that then at the end of the day renders cohabitation dangerous and intolerable. What was interesting, I came across a case where the court, in a very old case, of Bernardi versus Bernardi, a 1944 case where the court found that attempted murder of the plaintiff by the defendant did not amount to constructive desertion. That was really frowned upon, and there was a lot of critical judgments that followed hereafter on that specific finding. But yeah, you will also see that listed is physical violence between the parties. And that then caused one of the parties to move out, where normally it would be malicious desertion because the party left, but in this instance, life would be so unbearable for the, if I can call it, innocent spouse, that he or she need to move out. Now, if one look at this, you will note that it is the divorces in Namibia is wholly based on fault, either a guilty party and an innocent party, and that is why I said right in the beginning, we are really still in the dark ages in this regard, and the judge president and also subsequent judgments have really voiced their concern with this, in that the issue of the marriage have irretrievably broken down, that's not the issue. There must be fault. And unfortunately, society has changed to a very large extent in this regard. And I will give you the citation of a few cases where the High Court has discussed this specific issue, but to date, we have not moved forward in the form of legislation regulating this and removing the fault base of divorce out of the Namibian matrimony or family law. No, that is not. That is, you will remember, if I can just go back, that in supervening incapacity is not malicious desertion because of the fact that it's a physical incapacity that one of the partners suffer. So unlike with refusing marital rights, if there is supervening incapacity, it would not qualify as malicious desertion. I don't think that he or she will be able to use that as a ground for divorce. That doesn't, because it doesn't qualify as malicious desertion. So you won't be able to use it as a ground. That, as I say, the book, this is with reference to insistence on intercourse only with contraceptives. Now, this book that I'm referring to is also very, very old. And in the meanwhile, I think that things have changed substantially in light of HIV/AIDS that is currently rife. But I must also confess, I haven't seen a case dealing specifically with that. So I don't think the courts have been called upon to decide on it. But just as the cases that I've referred to that deals with the fault base of divorces in Namibia have indicated that the morals of society has changed substantially, and it is not the same as it was in 1935. I think the same can be said for that specific issue. But as I also said, I do not know of any cases that deal specifically with that. The third or the second common law ground for divorce is adultery. Now, adultery is the voluntary sexual intercourse between a spouse and another person that is not his or her wife or husband. Adultery is the only ground of divorce where the court can grant a final order of divorce without granting a restitution of conjugal rights order. Which means, in other words, when the matter is served before court and there is an affidavit admitting adultery by the guilty party, then in that instance, the court can, under certain circumstances, grant a final order of divorce. You'll find in those affidavits that the guilty spouse, if I can refer to the party as such, would then also say, I admit I committed adultery, and I also do not want to restore conjugal rights. I plead for final order of divorce. But the adultery is the only ground of divorce in which a final order of divorce can follow the same day. What better proof do you need of adultery than a child born from another lady other than the wife of the husband?
So that would also be fine. You could probably define.
You will find that in many of the particulars of claim, that specifically would be referred to. And we must just understand that this is not with reference to children before the marriage. It's children that were conceived during the course of the marriage. And the plaintiff would then state that the defendant has made himself guilty of adultery, and from this adulterous relationship, a child was born on such and such a date. If obviously the plaintiff know about the date, etc. But you find it that it is specifically referred to. Yes, that is condemnation of adultery. Condemnation of adultery.
Yeah.
Now, if the adultery is condoned, then you accept your spouse back, then there will not be a final order. Therefore, your plaintiff, or it can also be the defendant if there's counterclaims, will then specifically state that the adultery was not condoned. And then a final order of divorce will follow. If the plaintiff was in an adulterous relationship, you will also find that he or she then prays for condemnation of their adultery. And they pray for condemnation from the court. They're not from the defendant, but in that case, the plaintiff was the adulterous party, so there will still be RCR proceedings that follow. It will not be a final order. But if the plaintiff alleges adultery and does not condone the adulterous relationship, then a final order can follow. When there is a condemnation of the adultery, parties reconcile, the matter will be removed from the roll and it will be regarded as finalized. If the guilty spouse then again commits adultery, the matter will come back to court, but not on the same case number in all probability. It will come back to court on a new summons, and then this applies. I did not really discuss, you will note I did not discuss the issues of incurable insanity or declaration of habitual criminal. Unfortunately, due to time constraints, I did not have the time to deal with it. But, and I must also confess I haven't had the time to really research this issue, but I am about to do, because I just finished a case where the parties, the case before me is one of a divorce matter, where the defendant in this matter is alleged to be incurably insane, and there was a curator appointed on behalf of the defendant in this matter. So he was unable to testify, but the curator ad litem that was appointed on his behalf testified. Could obviously not place anything in dispute in this matter as to the conduct. Now, in the specific case that I have dealt with, the basis or the ground of divorce was not incurable insanity. It was malicious desertion because of the defendant allegedly, prior to having been certified, has made himself guilty of abuse of alcohol, and when he abused alcohol, he became very abusive, and there was a lot of physical violence involved. But that was only when he drank. So the basis for the or the ground for the divorce is then because of the malicious desertion. But there's also a reason why the summons was framed that way, because it also relates to proprietary rights. In a fault-based, if it's either malicious desertion or constructive desertion, the issue of the proprietary rights can come into issue. And there was an application for the court to make an order in respect of the property that is situated here, as the defendant allegedly did not contribute, that his rights be forfeited. If the applicant, and how I understood it, and that's why I haven't really applied myself to it, so I'm just sharing it with you. But as I understand it, if it is a case of the ground being incurably insane, there would not be, the plaintiff would not be able to bring an application for forfeiture of proprietary rights. So there was method to the madness, if I can call it so bluntly, in drafting the summons. So that is why I say I have not really researched this, and my judgment is due in January. So I have a bit of homework in this regard to do in December. But it's a very interesting legal principle to consider, and legal argument that was advanced during the course of the heads of argument. But in respect of habitual criminal, obviously, you all know that coming from the criminal court, what the consequences is of a declaration of an habitual criminal. That is then imposed by the regional court. So that is then also ground. I did not take it any further. So there's in common law sentence of life imprisonment, but so you can understand why a plaintiff would, in certain circumstances, use that as a ground of divorce, but that would really be the exception to the rule, as is incurable insanity. And that is why I earlier indicated that malicious desertion, constructive desertion, and adultery is your main grounds of of divorce. Okay, now what regulates divorce proceedings in the High Court? Once the parties decided that is the route to go, and plaintiff then files summons, then the rules of the High Court and the practice directions, referred to as the PDs, and I'm sure you have dealt with it in a week past, is then there to provide for a court-driven process for the conduct of the proceedings in terms of Rules 3.1. Now, I'm sure that the previous lecturers have emphasized the fact that you cannot read the rules alone. You need to read it in conjunction with the PDs, the practice directions, and vice versa. Your practice directions are your procedural guidelines issued by the Judge President of Namibia in terms of Rule 3 for the orderly conduct of court proceedings. That is like in your lower courts, you have your Magistrates Court Act and your rules as to how to apply the Act. So in the High Court, however, you do also have the High Court Act, 16 of 1990, but you will work 99% of the time with the rules and the PDs. Now, undefended matrimonial matters is on the residual roll. The High Court roll consists of 3 parts, namely the managing judge's court roll, the residual roll, and then the criminal roll. The managing judge's court roll is exactly what it says. Once a matter has become defended, it will be allocated, docket allocated to a managing judge who will then manage it from that point onwards. The residual court roll, and this is specific, and I've taken this definition from the definitions in the rules. Residual court roll means a court roll for the hearing of a matter not dealt with by a managing judge, including urgent applications, interlocutory motions not dealt with by a managing judge, unopposed matrimonial causes, or any other cause as may be in the judge president's discretion, be arranged for the expeditious dispatch of business of the court, the dates and the purpose whereof published by the registrar at the commencement of a legal year. The undefended matrimonial court then obviously deals under the residual roll. Judge Westhuizen will then deal with you with the rest of the matters that are on the residual roll, so I will not go there. But it is important to note that the undefended matrimonial matters are matters that have not been assigned to a managing judge, and it includes then action for divorce, annulment of marriage, custody and control of children of the family, a protection order against a spouse, parent, or child, and the division of the joint estate in the matrimonial cause. This is specifically set out in your PDs 59 section 9. Now, as I indicated on the previous slide, the residual roll is published by the registrar at the commencement of a legal year. So these are fixed dates. This is not random dates where one can decide when and where and how. The undefended matrimonial court roll is scheduled for every Monday morning at 10 in the main division, which is in Windhoek, and then every fortnight at 10 o'clock in the morning in the Northern Local Division. This is also set out in the practice directives. If you then set a case down on the undefended matrimonial roll, it needs to be for one of these dates. The legal practitioners know in the beginning of the year already which dates it will be. It does not change. If you work on e-justice, and I don't know whether the issue of e-justice has been discussed with you yet, but it also give you, it deals with your specific court rolls on e-justice. So once a matter is postponed and after RCR was granted, then you will, on e-justice for instance, only be able to postpone it to the next motion date that deals with undefended matrimonial court roll. You can't postpone it to another date. That also applies to paper files. You will, the paper files is in the process of being phased out, but there are still quite a few paper files when it comes to undefended matrimonial, but they are rapidly decreasing. So the majority of the matters on the undefended matrimonial roll is on e-justice. The undefended matrimonial roll is not assigned, as I already said, to a managing judge, so it's the judge on duty that will then deal with this role. And at this point in time, it is the judges that are in the application stream, not the judges in the in action, that will then attend to the undefended matrimonial role. Because of the number of cases that can be on a Monday morning on that specific role, the assigned judge then also have the assistance of 2 or 3 research assistants, because you literally need one to call the cases, the other one to make the notes and keep up with everything. It can, on a Monday morning, it can go up to 100 as much. And you will appreciate, if you don't have assistance. Even technically, undefended is fairly quick, but when you deal with RCR matters, it takes time because you need to record evidence, and that really takes up a lot of time. So on average, I checked last night, I saw there was 1 paper file that was dealt with on Friday, but the court roll for e-justice was 14 pages long, which have 4 cases on each page, minimum 4 to 5 cases, so you can add it up if you do the maths. So as a norm, it would be 50 plus on the undefended matrimonial roll on a Monday. There's a lot of preparation that involves in that. Therefore, the judge on duty cannot do this without the assistance of research assistants like Charlotte, because each and every case needs to be opened on e-justice. It needs to be, each document that is filed need to be perused to see what is exactly the position in that case. Has the PDs been complied with? What will then happen is that the research assistant will file a bench memo setting out, and this is to assist the judge, because you can understand if you have 100 cases to prepare, you will not be able to do it. Judges like Judge Wetele, and Charlotte would have first knowledge of that, who is in the application stream. If he has undefended matrimonial role, he would come in on a Sunday and he would prepare, which means that the research assistant by that time would have had to prepare already, upload the bench memos, because obviously the judge dealing with the undefended matrimonial role need to go through that case personally as well to satisfy him or herself that the case is in order. That it's an immense amount of work. You must also remember thereafter, it's not the end of it. Now the orders need to be done. Also due to the nature of the matters that the court deal with, the litigants can be quite persistent in getting the orders, and the orders need to be out within 2 days after the court session. So that again, so once you have, you're finished with the business of the day and you retire to chambers, then there's a lot of work that need to be done. Again, with the assistance of the research assistants, that makes it easier. But the enormity of the work still remains. So that is basically what you will do if you do the undefended matrimonial role. That's the type of preparation that you need to do. It is easier if you prepare a paper file, because you can quickly file, you can put it into date order, and you immediately see something. It kind of stands out if there's a problem. It's not always that easy to see something on e-justice. So you need to be quite careful in preparing your e-justice court roll. We all know, as presiding officers, you write, but you're listening at one side to the counsel, and you record the witnesses' evidence, and then the order needs to be made, and this issue is addressed and that issue is addressed. You can't keep up. You can't. So the research assistants in court are invaluable, and that is why one is not enough. You will see on, and as we speak, that if the list of research assistants is made available who will go with the duty judge to court, It will normally be 3, but no less than 2 though. So, and you must also remember that sometimes these files are this big, because they have gone through the mill, and although they're undefended, the poor research assistants need to carry all these files to court, up the stairs and down the stairs. So in that sense, it's easier with e-justice. But yeah, they will be able to share with you their experience in that regard. Charlotte? Yes, but remember, and I will deal with that just now, if there's a variation to the order, then they are expected to file a amended order by 12 the next day. Doesn't always happen. And there's timelines within which these orders need to go out. So it is important that the whatever is the order of the court is correctly recorded. Okay, so what happens from the time of instituting proceedings in the High Court? First of all, there's the issue of the combined summons. You would have dealt with the issuing of the combined summons. I'm not going to deal with that, but you will note that from your rules, Rule 7. And Rule 7 also set out in particularity what should be contained in the combined summons. So I am not going to deal with that again. Together with the combined summons, for service on the defendant, there need to be a certified copy of the marriage certificate. That is to be filed or served on the defendant together with your combined summons and your particulars of claim. This you will find in Rule 87(1)(a). Now, at this stage, it's only the certified copy, and also on e-justice, when the summons is issued by the registrar, same time as when the particulars of claim is filed, and the particulars of the litigant in terms of Rule 6, a certified copy of the marriage certificate need to be uploaded, and if there is an antenuptial contract, that needs to be uploaded as well. These then go to the deputy sheriff, who will then serve the process and the documents on the defendant. Now, you would have probably also dealt with service process, and that is in terms of Rule 8 of your rules. But unlike in Rule 8, where the summons can be served by attachment or on the place of domicilium or on a person older than 16 years old, a summons in initiating divorce proceedings need to be served personally on the defendant. Once that is served, the defendant has 10 days from date of service to deliver a notice of intention to defend. You must remember that this calculation of the days is not including the period of the 10th of December to the 15th of January when the court is in recess. So if the summons is issued late in December, the 10 days will only run once recess is over. Or if it is served, say, before, on the 15th. I think the messengers of court and the deputy sheriff's office is also closed, run about mid-December if memory serves. So if it is after the 10th, the days will only start to run from the 15th of January. So you can't then first day, on defendant matrimonial day in January, say, right, now I want to move for divorce. You can't do that. So you need to take that into consideration. And just on the issue of service, must remember that service can only be effected between 7 in the morning and 7 at night in terms of Rule 8.7, unless the court specifically grant an order to the contrary. So once, in the event that no notice of intention to defend is delivered, then the matter can be enrolled on the residual roll, more specifically in the undefended matrimonial roll. Now the days, remember, is court days. It's not calendar days. So you need to, that need to be counted. It cannot be enrolled short, because then it's going to be removed from the roll. And I can promise you that the research assistants will pick it up, because they would count it specifically to see that the DS has been complied with. Otherwise, it's premature. As already said, service of all process and documents initiating proceedings in matrimonial matters must be served personally. Where the service of the combined summons has been effected more than 6 months before the matter was set down on an unopposed basis, the combined summons must be reserved. I see I have a typing error that says reserved, but it's reserved. So if the summons was inactive for 6 months and only served then it need to be, well, it's served, my apologies, it's served. For 6 months, nothing happens. They do not enroll the matter. Then the matter need to be reserved. Obviously, if a file, be it paper or e-justice, is inactive for 6 months, then Rule 132 then come into play, where the court need to deal with inactive matters. And where the plaintiff would then be given the opportunity to show cause why the matter should not be removed from the roll and be regarded as finalized, and why the court should not consider cost. But that is just a side comment. So what is important is when the summons refer to an adulterous relationship and a third party is mentioned by name, the proceedings obviously affect that third party. So the summons need to be also effected on that person. So if that person is residing in Namibia and his or her address is known, then the service must be effected. But I must also add that I think sometimes practitioners avoid adding a name, because they know the moment that they add a name, the court will require a return of service on that specific person. So in many instances, these particulars of claim would indicate that the defendant had an adulterous relationship with a person with whose name is unknown to the plaintiff, in order to avoid that. In terms of your practice directions, 8, return of service must clearly state certain issues. And you will find, and I'm sure that Charlotte and even Nelly would agree with me, that your returns of service are not always complete. They are really lacking, and we see that from certain jurisdictions, in spite of a lot of correspondence exchanged by the registrar with these deputy sheriff officers, the returns are still not as it should be. But where the return, for instance, would say that on such and such a date at such a place, the process was served on the defendant. The defendant who? Who is the defendant? It's not sufficient just to have in the heading of the return of service to say it is a matter between Ms. X and Mr. Y, and that the court must then infer from that it was served on Mr. Y. The return of service in terms of the PDs must indicate a full name and surname, and if available, identification number. I must say that is something that I see often, that the identification number is also added. But I've seen quite a few returns of services just referring to the defendant, and that is insufficient. Well, obviously, the defendant of the deputy sheriff will then depose to an affidavit in that regard, setting that out. I think with protection orders, same, where the one party does not want to accept, but it must be served. Otherwise, you cannot move the matter forward. The summons, you will see, also have a heading of what the nature of the process is that is served, like summons or RCR, not RCR, but restitution of conjugal right order. And then in the body, it need to also specify exactly what is served, because these annexes to to the process, like for instance, on the summons, there would be the particulars of claim, there would be the certified marriage certificate. On an RCR order, there would be the court order, etc. So it need to, on the particulars of claim, there might be further annexes. So it need to specify so that the court is sure that the defendant has received all the process that is due to be served on him. So sometimes the return of service can get fairly long, especially if there's a lot of documents that has been served. You will, in a divorce action, not so much, but in your other actions, where there's a lot of annexes, you will get long lists of the documents that has been served. And that need to be obviously in line with your annexes that is, say, for instance, filed on e-justice. So if it's Annex E and it is a certificate of balance, it need to correspond. This is where we now deal with alternative service of process, because we all know how humans can be like, and you know that the divorce summons is coming, and you don't want it, so you run and you hide. So therefore, the rules do provide for alternative service of process. The alternatives are additional citation and then substituted service. Now, these two services in many instances overlap, but they are also very different. An additional citation is in the instance where the court process in instituting legal proceedings against the party must be served outside the Republic of Namibia. When it is a substituted service, that is required when direction is sought in regard of service upon a party who is believed to be in Namibia, but that the one or more forms of service as provided for in Rule 8 is not possible. The whereabouts of that person is then unknown. So depending on the circumstances, these are then the options that can be followed. Now, your edictal citation would be where, as I already said, the parties outside South Africa, Germany, wherever. We have quite a number of edictal citations going to Germany, especially in divorce matters. But yeah, so then your substituted service is can be in Namibia as well as outside Namibia, and I will get to that just now. So before a party can proceed with this alternative service of process, specifically edictal citation, there's a number of rules and PDs that apply. You will note from your rules that your edictal citation is in terms of Rule 12. And you need to read that together with your practice directives. More specifically, I think Practice Directive 11. I can just make sure. 10. But you also need to read this together with Rule 11 and PD 9 that deals with service of process outside Namibia. Before a party can serve process or that institute litigation on a party outside Namibia, an application must be brought. This is brought an application for an edictal citation. Now, normally, an edictal citation would be dealt with in first motion, but because it deals with a matrimonial issue of divorce, it would be enrolled on the undefended matrimonial realm. So once an edictal citation application serves before court, it would get a unique application number. This is especially important when you deal with e-justice because it gets a motion number, whereas your main action would get a different case number, a matrimonial case number. And there are different acronyms for applications and in motion, and so for delicts and matrimonial or contract. And the acronym is important at the end of the day, especially on paper files. But once the edictal citation is, the application has dealt before court and the court grant the party to serve by virtue of edictal citation, only then can the summons be issued. And at the end of the day, the edictal citation as well as the summons would then be served in the country where the defendant find him or herself. There are essential averments that need to be made in an edictal citation, and the averments is also in the rules, so you just need to go through the rules. So we'll just quickly run through the averments that need to be there. But in an edictal citation, the grounds for the applicant's claim in the main action to be instituted must be set out. So a prima facie case, in summary. Then the nature and the extent of the relief that will be claimed in the main action need to be included. If the current whereabouts of the respondent is known, the manner of service which the court is requested to authorize, normally it will be obviously personal service, or where the respondent's whereabouts is unknown, then particulars, full particulars of the last known address of the respondent, the nature and the extent of the inquiries made by the applicant to ascertain the respondent's current address, and the facts indicating the most effective manner in which the service should be effected. Now, you will remember a few minutes ago I said to you that in some instances that the edictal citation is only in respect of outside, a process that needs to be served outside Namibia, but that a substituted service can also be outside. It's inside Namibia as well as outside. So if the whereabouts of the defendant is unknown, there would be an edictal citation coupled with substituted service that need to be obtained. And then obviously any other information which may assist the court in its decision. And then a statement that the form of service requested to be authorized will in all likelihood result in the proceedings coming to the knowledge of the respondent. That is in respect of the edictal citation. Now when it comes to the substituted service, and this is now where we are, the defendant is residing in Namibia, but he has vanished. He is running away from the deputy sheriff, and you will not believe how many instances this happen, where the defendant would do everything in his power to avoid service by the deputy sheriff. And how many returns of service would come back to say, been there, nobody there, cannot trace him. And that is when also, if the whereabouts of the defendant is unknown, and he is suspected to be in Namibia, that the substituted service route will be followed. If the whereabouts is unknown, then it is also an application to the court, where an application is then brought, wherein the plaintiff would then set out also or apply for leave to effect the service in Namibia by way of publication of a document. And I was actually looking for something last night in all the newspapers, but 2 o'clock in the morning, you don't find something as quick as you want to. But that is when, for instance, where you will find that a whole summons is published under the classifieds in the Sun, or in the Republican, or in the Namibian. In a case like that, the plaintiff will aver in his application that the defendant last known whereabouts is, say, for example, Swakopmund, and that the plaintiff is well aware that the defendant used to read the Namib Times, which is the local newspaper in that area, and that the plaintiff is convinced that if the court grants the substituted service and they are able to publish the summons in the Namib Times, for instance, that this will probably come to the attention of the defendant, either by him reading it or family members that reside there, because that was his last known address. Say, for instance, he lived in Safierstraat in Koeisipmond, but he's now nowhere to be found. So that is when a substituted service will be will be applicable. So you will agree with me if I say that the two means of alternative service kind of overlap in certain instances. The substituted service does not always need to be on application. If the whereabouts of the defendant is known, it need to not be on application, then an application can be raised from the bar, where the court is then requested to say, look, Mrs. X is residing in Safierstraat in Koeisipmond or in Acaciastraat in Swakopmund. We know she's residing there. The messenger of court cannot affect service. But we have spoken to her. She works on the mine. It's impossible to get it served because, remember, the service needs to be personal. And she requested that some of the process be served on him by email. So then, say for instance, some of the documents can be served by email. But that is an application that can be moved from the bar. It does not need to be on application. And then obviously in all these instances, proof need to be presented to court of the service. In a substituted service where there was application and the summons is served in the newspaper, the tear sheet of the newspaper would have to be attached to the documentation on the return date, so that the court can see that it was indeed served, because the whereabouts is known. So it's not the rules make a distinction between the whereabouts being known and the whereabouts being unknown. If you if you look at Rule 13 and PD 11, there's a definite distinction between the whereabouts being known or not. I think that if you know where the person is residing, and the attorney has spoken to her, and she said, "I'm here. I'm living at this address, but I'm working at Rossing or Husap," and the deputy sheriff will never be able to serve it on me because I work from 6 in the morning till 8 at night. So he won't be able to serve within the hours of 7 and 7. But I'm aware of it, and any documents that you wish to serve on me, you can serve by my email. then it can, but if you do not know where the person find him or herself, then you have to publish it. And that is when you will make use of the newspaper. No, you will find with the summons, they will contact the defendant and say, listen, I have a summons, meet me somewhere, and it's served. That would not necessarily be on the address, on the summons, but then the return of summons would say, I have called the defendant and have met him or her at this specific place, and a personal summons was effected. If you want to call it, yeah, for subsequent. Otherwise, if you don't know, you will follow the route. But just, for interest's sake, when you go through the classifieds again, they're not frequent, but they are there. They are there. In the north, specifically with these very remote villages, you will find that, and because there's no street address and there's no, that they would then contact the defendant, ask them to meet at the nearest school or the hospital, and then effect the summons there, the service of the summons there. You will remember that earlier I also referred to third parties, especially when there's allegations of an adulterous relationship, and that service need to be effected on a third party. If the party is known and the party is residing in Namibia, then the summons must be effected on the specific person, in terms of Rule 87.4. But if the third party is a resident outside Namibia, and his or her address is known, then a notice of the proceedings may be given to that person by registered mail. That is in terms of Rule 87.5. Where it is not possible to determine the whereabouts of the third party, outside Namibia, then the court may dispense with the service of the summons in terms of Sub-Rule 4 and Sub-Rule 5 of Rule 87. But then the plaintiff will have to show that reasonable steps were taken to ascertain the whereabouts of this specific person, and that they were unsuccessful in tracing. And in that instance, the affidavit would be deposed to set out the steps that were taken. As I said, I think in many instances the litigants do not name the third party by name because, and I think it would have been discussed with you, if a summons or a cause of action also affects another person, then you need to cite that person. But I think specifically when some damages for contumelial is claimed from that third person, then you have to, because you then pray for relief against that person. But in many of these instances where the person is the whereabouts is unknown, cannot be traced, then the council would place on record that they do not seek relief from this third person, and in that case the court might then dispense with the service of the summons. Okay, I see it is 10:30. I'm going to start with the enrollment of the hearing and then the subsequent hearing. So it's a new almost subject that I will now cover. So maybe this is an opportune time to break for tea. Good. Thank you. We will then break for tea.